Oh, this is Zuta speaking. I'm muted.
All right, so it's 6:02, and we are welcome to today's episode of Lawyer's Diary. Today promises to be a very exciting discussion because I have two of my very good friends. One is a coursemate, a brother, and the other one too is my boss in Accra. So I'll start by saying that as we all enter into business relations, as we build our brands, at a point in time, we want to employ people to assist us achieve our aim. And that comes along with granting and giving employment contracts. So today, our speakers are Dennis Boamah Okyere. He is a legal practitioner and a partner at Jando Asma. Dennis specializes in litigation, labor relation, commercial transaction, as well as corporate governance. And currently, he's in charge of the Kumasi office of Jando Asma. So Dennis is a big man. Dennis, welcome to the episode of the Lawyer's Diary.
Thank you, Onesimus. I'm glad to be with you this evening.
And then our next speaker is Stephen Osekisi. Stephen is an industrial relations officer and currently heads the Greater Accra Regional Office of the National Labour Commission. I'm sure yesterday. I'll please once you come in, you mute yourself. Just a minute, let me mute everyone. All right, so Dennis and then Stephen, you can unmute yourself so we start the discussion.
Okay.
Sure. All right, so you're welcome. Dennis and then Stephen.
Thank you.
Thank you, Onesimus.
The discussion will be in three
Thank you, my
phases.
senior.
We'll consider prior to employment, when we want to employ somebody in our companies, what are some of the things that we need to do as employers? When we also employ the person into our companies, what are some of the things that usually happens in terms of dispute resolution, in terms of grievance settlements, and then after, when we settle ways, how do we resolve it? That's when we'll come into the Labour Commission with Stephen to also explain things. So let me start with Dennis. Dennis, if I'm an employer and I want to employ somebody to work for me, what are the steps that I need to go through? What are the things that I need to consider? What should I do?
Very well, Onesimus. If you're an employer and you desire to employ somebody, as far as me being a lawyer is concerned, I will look at it in that angle. You need to first and foremost consider the age of the person, whether the person you intend to employ, does he have the legal age or does he have the age which is required in law for a person to be, as it were, employable. As we know, even though the contractual age in Ghana is 21 years, but we know that if you look at the Children's Act allows children about 16 years to be employed to do some amount of work, right? But when it comes to the kind of work that can affect the health of the person and all that, the person has to be about the age of 18 years to be able to do what we call the hazardous work. So if you're going to employ somebody to do work for you, you need to consider first and foremost the age of the person. Secondly, you need to also consider the capacity of the person, whether the person that you intend to employ, he has the capacity to be able to do the work that you want the person to do for you. And of course, you also need to look at the contract, need to negotiate the employer and the employee. What are the considerations? What are the terms of the employment? So that at any particular point in time, we are all clear on what is expected of the employee and what is expected of the employer. So that that becomes a working document each of the sides can refer to at any material time when there is a need to have some kind of resolution on an issue. So these are some of the few things you may need to consider when you intend to employ somebody. And of course, you must do all of these things with the Labor Act being at the back of your mind, because the Labor Act also implies certain requirements into any contract of employment. So you need to also be well informed as far as the Labor Act is concerned and the law on employment or contract of employment is concerned.
All right, you've mentioned some other things, but let's be clear on this. What is the legal age for which somebody can work in Ghana? If I'm an employer, should I require the birth certificate of the person to confirm whether the person is indeed eligible to work for me, and what is the legal age for working in Ghana?
The legal age for working in Ghana, we can say, is 18 years. Is 18 years. As far as the, what do you call it, the Children's Act and the Labor Act, I mean, is concerned. We can peg it at 18 years. But of course, the Children's Act allows for even the children to be able to do some amount of work, so long as it does not pose risk or significant risk to the health of the child. It does not deprive the child of education and other things which must be given to the child. The Children's Act allows, but the Labor Act actually criminalizes that as well. So there is that conflict in the Labor Act and the Children's Act. But we can say that the working age in Ghana is 18 years.
Okay, so the Constitution recognizes 18 years. There's an echo at your background. I don't know whether there are two devices.
No.
All right, so then let's manage it like that.
Well, I don't know if it's the fan at the background which is causing any problem.
So
I think it has stopped now.
So in terms of the age, I just want us to be a bit clear. I know the Companies Act mentions 21 years. The Constitution mentions 18 years. So if I am an employer, a layman employer, I've opened a block factory, I've opened, say, an engineering firm that I want to employ somebody, to be on the safer side, what should I do? Should I request for the person's birth certificate? And what should I be looking for? Is it 18 or 21? So I don't get myself involved in any future.
Yes. As far as, you know, employment is a contract, all right? But as far as employment is concerned, the age is 18 years, as far as employment is concerned. But contractual age in general is 21 years. But when it comes to contract, it's 18 years. So when you talk about, I mean, requesting for, I mean, of course, every company must do some kind of due diligence when it comes to, I mean, the people that you intend to employ. That is why mostly you require some kind of CV from the person to be able to know, I mean, a little bit about the person and know whether the person you are dealing with has the capacity and has the age which is required to be able to do the work that you want the person to do for you. So of course, as a company, you must be able to do some due diligence to see that the person that you intend to employ has the legal age to be able to do the work that you want the person to do for you.
Okay, so we are done with that of the age section. Now, I am the employer. What are some of the terms and things that I need to look through or look for in my employer or employee? When I'm drafting a contract with you, what are some of the things that I need to put inside my contracts?
Well, when it comes to contract of employment, of course, I mean, you must provide for remuneration, as we all know, because I mean, when we talk about employment, we are all employees. You need to know that you are well remunerated for in the contract of employment. Secondly, you also need to provide a means of some kind of disciplinary mechanism where there's a situation of misconduct. What mechanisms will be used as far as dealing with that kind of misconduct is concerned? It has to be provided for in the contract of employment. You also need to be able to spell out what are the duties expected of the person that you intend to employ. What is expected of the person? What are the terms of engagement? What is the portfolio? These are the things which you need to provide for in the terms of employment. But of course, because it is a contract, what at the end of the day is reduced into writing is the bargaining of the people, what they consider to be essential as far as the engagement is concerned. So of course, it will depend on the particular field, the particular sector, the particular custom, the particular trade, the particular usage that the person is to be employed in. We will not be able to, as it will have a tailor out contract for all cases, but it will depend on the particular field or the particular custom that you intend to, employ a person. But mostly, most organizations and most institutions, they have a working terms of, contract of employment that they give to people that they intend to employ, which normally would contain the essential things as far as the terms of engagement are concerned.
Okay, so are there, you've mentioned quite a few, but should it also include how the parties may want to sever ways in terms of termination clauses and then any other thing?
Yes, definitely. You need to also provide for if for instance, there's going to be termination, what is the required notice to be given, right? You have to provide for all of these things. And of course, the Labor Act also implies into some of these contracts in situations where, the contract does not provide for that. And I'm sure as time goes on, our discussion, we're going to realize how the Labor Act also implies into it and all that. Yeah.
Okay, so recently there was a matter which I was privy to. The company employed someone, but later the directors and then say the CEO came out to say that they didn't know anything about such a contract. And so such contracts was ineffective and they had to cancel it. If I'm an employee or a person who wants an employment, in order to secure my work, who should I look for in terms of the signatories? Who should sign my employment contracts?
Well, in this particular situation, you're looking at, being a lawyer, I will look at, if it's a company, I will look at who acts for the company, right? Or who is the authorized person for that particular company. Generally, by the companies that we know that it is the directors who, act for the company, the board of directors who act for the company. Or if, the act, they have given power to the managing director to act. We know that it's the managing director who acts for the company. There are sometimes who they may have given the power to an officer who is in charge, maybe a human relation officer who is in charge of employment, situations or scenarios. So you may want to look at the particular working structure of the company that wants to employ you and what should go into it as far as that particular company is concerned. So it will depend on the company that is concerned. But I would say that generally, because when it comes to company, you are looking at the directors of the company because they act for the company. Or unless they have given that power to somebody to act on their behalf, then of course that person vicariously act on behalf of the company. And of course, this act also binds the company as well.
So should I as an employee or as an ordinary person who wants employment, request for, say, a power of attorney or some kind of authority granted to the HR or any other person, if the person is not a director or, say, the CEO?
No, the power, the human relation officer does not need a power of attorney from the company before he can act. So long as he is an officer of the company and the company has held him out to be able to do the job that he is doing. And now, of course, you will know that it is.
what if the person was just acting in the floric of his own and the company wasn't aware? Because recently there were instances where, say, the HR personally signed off some contracts before leaving, and such acts will be deemed to bind the company. But the company came out and said that no, they didn't authorize the HR to sign such contracts, and so thereby they were therefore terminating all contracts. How do I, as one employee, save myself from such situations?
Yeah, but you know that there is what we call the presumption of regularity, right?
Yes.
Yeah, so me, the outsider who does not know the internal, whatever is going on internally, you have held the person out as being able to employ people, and he was doing it in the ordinary course of his duty. So if a company, you no longer have a particular person doing the job that we all know that he's supposed to be doing, you must affix a notice. There must be a notice that this person is no longer able to do the job that hitherto he was doing, so that the general public cannot be misled by them. Because, I mean, we can presume that if this particular person works with this company, and hitherto he has been employing people, then he's doing it in the normal course of his business. It will be a little bit impractical to require an employee who, as it were, is at the mercy. You know, in Ghana now, getting a job is very difficult. It will be very difficult for you to go asking for power of attorney from somebody that you are, as it were, seeking for employment for. You know, you want favor from the person you are demanding for power of attorney. You'll be seen to be some way. So the law actually.
Your point is that it is okay if an individual presumes that the person signing my contract is the right person.
Yes,
so long as the person works in the company.
Come again.
I need a clarification, because when I'm sitting here as an individual who doesn't know anything about the law.
Sure. So, but you know the law.
No. At this point, you are the expert. So, if I go to say I come to your law firm,
sure,
and then your clerk signs off an employment contract for me, I'm supposed to be in your clerk.
But you know, on this one, if a clerk signs an employment contract for you, you should know that it is not in the ordinary course of business for a clerk. I mean, for a clerk to be signing contract.
I may not know the duties of a clerk in your office, because
generally, it is not within the purview of clerks. I mean, generally, it's not within the purview of clerks to be signing employment contracts. So you yourself, as an employee, you should be put on notice. You should be put on notice if you work to a facility or an organization, and then you realize that it is a clerk who is giving or signing contract of employment, and is doing it without any form of supervision. There is nobody there to corroborate what he's doing. It should put you on notice. But if, for instance, I walk into an organization and the person is doing it in open, everybody, all the directors, everybody see that he's doing it, and he's reputed for doing that particular job. We are looking at a person who has been held out to be doing a particular job. So if he has been held out by the company to be doing that particular job, then of course the company cannot subsequently try to, avoid the repercussions or the consequences of any contractual obligation that the particular clerk enters into on behalf of the company, if the person has been held out to be performing those functions, to my mind.
Okay. Now when it comes to Stephen.
Yes, boss.
So now you work at the Labor Commission. What are some of the practical issues that comes to your office in terms of the contract itself, signing of contractual documents itself, and problems that comes along with the document itself?
Well, I think that what we have realized over time is that for most of the contracts that we get to see, you would realize that the obligations the parties owe each other is not really clear. That is the first part. And then the second part relates to, in the event of wanting to end the relationship, what we are supposed to do.
Yeah.
You would find that is also not present. And then if The last bit relates to how we resolve issues when they come up at the workplace. These three elements, for some time now, we can trace them in most of the disputes that come before the commission. So that the terms, i.e. the obligations the parties owe to each other, the grievance procedure, and the last one relates to how we resolve disputes. Usually you find that these elements are missing and they become problematic.
So in terms of your side, it's just with respect to clarity for the rights of the parties in the contract. And then grievance procedure, if there's any breach, how do we resolve it? Okay. That would be part of our third leg for the discussion. So let me go back to Dennis then. Dennis, in terms of the labor law, does the employer and employee have any rights? Do they have any rights in the course of their employment?
Yes, definitely. The Labor Act provide for some rights of the employer and rights of the employee. For instance, is the basic right to terminate the contract of employment. And I think essentially we're going to be talking much about that as far as, to this evening discussion is concerned. Both the employer and the employee has the right to bring to an end the contract of employment, but of course, under some parameters. And I'm sure as the discussions go on, we will be able to know some of the parameters under which the contract can be brought to an end.
All right, then let's continue.
Yes. So if maybe you can ask specific questions, then we can.
All right, so in terms of, you brought about termination, and I also know about dismissal. Can you differentiate between the two, termination and dismissal? What is termination and what is dismissal?
Great. You know, when you look at the Labor Act does not provide for dismissal as it were. The Labor Act provides for termination, but mostly dismissal is premised on a wrong. Dismissal is premised on a wrong, but termination is not necessarily premised on a wrong. The Labor Act provides circumstances under which the contract can be terminated. They are very specific as far as, the grounds under which the contract of employment can be terminated is concerned. So dismissal, to answer your question, dismissal is premised on a wrong. There has to be a wrong that has been committed by the employee to be the justification for the dismissal, right? If there is no justification, there becomes a wrongful dismissal. And there are, remedies available to the employee. And so in that situation, there has to be a justification for the action of the employer, i.e. discharging the employee from his contract of employment. There has to be some avenue given to the employee to be heard. Of course, there should be the hearing process where the person is heard on whatever offense he has committed and given opportunity to answer to it. Then after that, whatever action that has to be taken can be taken, except for situations of summary dismissal, which we are going to be discussing. In situations of summary dismissal, you may not go through the process because they are usually occasioned on what we call gross misconduct. They are very grave and so serious that normally it is done in the spur of the moment, maybe out of anger. You see, that you may be summarily dismissed without going through the process. And mostly, when cases of that instance come before the court will normally sanction it, even though, the person was not taken through the process. A critical example is the case which happened at Agogo Hospital, Presbyterian Hospital, Agogo versus Guatin, where you have a senior midwife nurse who was working in the hospital. And I don't know if I may continue or I should
continue.
Yes, so who was working in the hospital? It so happened that a woman called A came about 9 p.m. because she was in labor. She got to the hospital and then the woman, the midwife, put her to rest because she told her that it was not time for her to deliver yet. But this woman actually felt that she was in labor. She felt that something was coming out. She went to the WC to urinate, but it happened that it was a child. She called for the midwife. The midwife came and still insisted that no, she's not in labor yet, so she should still hold on. The woman left the washroom trying to make her way back to the bed, and then she delivered on the bare floor in the pool of blood and called out for this midwife. When the midwife was called for, she came and then insulted the woman instead of showing some kind of sympathy to her, and even slapped her twice. Okay, and even slapped her twice. So what happened was that subsequently, the hospital invited her to come and explain her conduct. She disrespected them. They queried her. She didn't answer. So they summarily dismissed her. Now she sued at Joaso Circuit Court on the basis that, I mean, they didn't take her through any form of process. And the court sanctioned, initially the Circuit Court in Joaso, they agreed with her that some terms of, I mean, conditions in the employment, the conduct of employment was not followed. They didn't go through the procedure. And so the dismissal was wrongful. But when they appealed to the Court of Appeal agreed with the school that what the woman had done was so grave and so serious that the school need not take her through any form of process. So there can be situations where you can be dismissed if the situation is so grave and so serious that the person need not even take you through any form of process. But normally when it comes to dismissal, it has to be occasion on a wrong, and you have to be taken through a process laid down in the contract of employment for dealing with that issue. But termination borders on the Labor Act. The Labor Act does not specifically mention dismissal, but in the international parlance, they use dismissal and termination interchangeably. So there is that kind of confusion. But if you look at the contract, the Labor Act very critically, you can say that dismissal brings or is a discharge from employment. To that extent, it is a form of what? Of termination, as it were.
So if I understand you very well, your point is that when I want to terminate as an employer, I don't need to give any reason. I can terminate. In as much as I go through the terms of employment by giving you notice or payment in lieu of notice. If I own my company and you are my employee, I can one morning write to you and say that Dennis, Boamah, Okyere, tomorrow don't come to work. I've terminated your appointment. All that I need to do is to pay you your notice money. Is that the case?
No. You see, that's why I said that the dismissal, they are usually based on misconduct.
No, I'm referring to termination. I'm referring to termination, not dismissal.
No. Okay. You know, in common law, there is what we call the principle of mutuality, which says that because the contract of servitude is not a contract of slavery. Hello?
Continue. Yes, I can hear you. You can continue.
Yes, it's not a contract of slavery. It means that the employee can bring his contract of employment to an end. And on the strength of that principle of mutuality, the employer could generally also terminate the contract of employment without giving any reason. But you will realize that there has been some inroads which have been made by the Labor Act. The Labor Act does not envisage terminating contract of employment without giving reason. It doesn't envisage it, but the court have been dealing with the Labor Act, as it were, sparingly. What has been going on is that in some instances, even though the Labor Act is there, they still went to use the common law. But the current position of the Supreme Court. Hello?
Yeah, then let's continue.
Yes, we're listening.
The current position of the Supreme Court is that if a person wants, because termination with given reasons was provided for by the Labor Act, there is a procedure laid down in the Labor Act for dealing with it. And that is that you have to go to the National Labor Commission. So the Supreme Court, as it were, extricated itself from dealing with the situation of termination without giving reason, because it says the causes are common law. the procedure of terminating without giving reasons was a recent development provided by the Labor Act. And the Labor Act provides that you should go through the National Labor Commission.
No, I want to understand in simple terms. If I want to terminate my employee's appointment, do I need to go to the Labor Commission to do that, or I can just terminate?
Not you, not the employer. But what I meant to say is that at common law, the employer can terminate the employment without giving any reasons at common law.
Sure.
Right? That was the law till the coming into force of the Labor Act. And of course, most of these statutes are meant to protect the marginalized. It's meant to protect the oppressed. Because if you look at the Supreme Court, they were of the view that it produces some kind of docility in the employee. It is made in tolerance of the employee, right? It is meant to oppress the employee, right? If the employer can get up one day at his own whim and caprice and then terminate the contract of employment without giving any reasons. And it is for that reason that the Labor Act was brought into force. But the Supreme Court said that the Labor Act also provided a means of dealing with a redress if an employer terminates the contract of employment without giving reasons, right? So to answer your question simply, if you're an employer, you cannot terminate a contract of employment under the Labor Act without giving reasons. To answer it straightforward, you cannot terminate a contract of employment under the Labor Act. You cannot terminate a contract of employment without giving reasons, because if you look at section 15.
Yes.
Section 15 of the Labor Act, right? It gives the situations under which the employer may terminate a contract of, employment. One of them is when there is a mutual agreement between them. Right?
Mm-hmm.
Hello?
Yes, go ahead.
Yes. When there is mutual agreement, it does not envisage a situation where an employer gets up one day and at his own whim and caprice says that you go home. I'm no longer interested in working with you. It doesn't envisage that kind of situation. And it is done so that there can be some kind of security for the benefit of the employee, and the employee can be able to continue to do his work without that kind of oppression coming from what? The employer. So the Labor Act does not allow for that. But what I was trying to say,
okay, you finish.
What I was trying to say is that in a situation where an employer terminates the contract of employment without giving reasons, if you go to the court, as it stands now, the Supreme Court, they will tell you that you should go to the National Labor Commission. You understand what I'm saying?
Yes, but my concern,
they will tell you to go to the National Labor Commission.
The concern of other people has been that, contracts are not contracts of servitude. We cannot force people to work for companies. So it should be both sides. In as much as you can't force the individual. The individual can wake up today and write you a resignation letter that I'm resigning from your work. All that he needs to do is to give you 1 month notice. So that should also be the portion of the employer, so that if the individual can leave only by giving me notice, I can also terminate by also giving you notice.
That is the principle of mutuality I was talking about, which existed at common law. And that was actually the position of our Ghanaian courts till the coming into force of the Labor Act. And you and I know that when it comes to the category of the laws, when you put them into category, you would agree with me that statute precedes or overrides case law. Statute precedes or overrides case law. So the Labor Act has made
the statute precedes. I'm here as an honorary Ghanaian. So when you say statute precedes, what does it mean?
Okay. Basically, what it means is that when there is a seemingly conflict between the statute and the case law, we will go by the statute. I don't know whether that will help.
So the statutes are the laws which is specific to a certain
So the statutes
area.
are the laws which have been passed by Parliament.
Okay.
They have been passed by Parliament, and usually they have a mischief in mind. They pass it to deal with a particular situation. Now, the Labor Act has made some inroads in the common law position on the principle of mutuality, that an employer can relieve an employee from his duty at his own whim and caprice. According to the Labor Act, Section 15 in particular, it gives the grounds for termination of employment. One of them is that there should be mutual agreement between the employer and the worker. 2, by the employer on the death of the worker before the expiration of the period of employment. 3, by the employer if the worker is found on medical examination to be unfit for employment. 4, by the employer because of the inability of the worker to carry out his or her work due to I, sickness or accident, or II, the incompetence of the worker, or III, proven misconduct of the worker. So clearly, the express mention of these scenarios means that the Labor Act expressly or impliedly does not envisage a situation of terminating without giving reasons.
Okay, I mean, recently there was, and this is up for discussion, there was a Supreme Court case, I think Kote, JSC and Charles Afran versus SDB Bank. They also made some pronouncement that an employer is not really required to give any reasons for termination. At common law, an employer and employee are free and equal parties to contracts of employment. Hence, either party has a right to bring the contract to an end in accordance with its terms. Thus, an employer is legally entitled to terminate an employee's contract of employment whenever he wishes and for whatever reasons, provided only he gives due notice to the employee or pay him his wages in lieu of notice. He does not even have to reveal his reasons, much less justify the termination. And that was in 2019. It was a Supreme Court case. So I want to find out probably there may be a new development to what I mean. The Supreme Court also makes binding decisions.
I agree,
so
but
one of the positions of the Supreme Court that I don't need any reason, in as much as the employee or the individual can write to me that I'm going. I can't go and force him to come and work for me. All that he needs to do is to give me notice. Equally, such rights are given to me as an employee too, as the owner of the company.
Yeah, Onesmus. Now, this particular case, we must look at it for the fact of it. We need to see when did this issue arise? Did it arise before the coming into force of the Labor Act? Because it is possible that even though it was held in 2019, it is possible that the facts culminated before the coming into force of the Labor Act. So the Labor Act, it was not that act, there was no accrued right at the time. I'm not privy to the fact of the case you are reading.
Sure.
Now, secondly, I also don't know whether your lordships drew the attention to even the existence of the Labor Act at all. Was the issue of the Labor Act, did they even discuss the effect of it at all in that case?
I want to also, if you look at the Labor Act, I want to open it and so we have a discussion on it.
Sure.
Okay. As part of the rights of an employer, the Labor Act is quite clear that an employer also has reserved the right to terminate, I think Section 8. Let me yes, just a minute.
Yes.
That's right. You're right.
Section 8, yes.
Section 8 says that as part of my right as an employer, I can terminate the contract of my employee. Because I'm looking at it from a point of, if we say I always need reasons, it becomes a bit restrictive.
You see, that section, sorry.
Or then it's,
okay.
So let him go ahead. Let the National Labor Commission man go ahead.
Please come into
yeah.
You see, Onesimus, you mentioned Section 8. Clearly, it reserves the right of termination for the employer. But let's not forget that Section 8 doesn't sit in isolation when it comes to the labor law.
Exactly.
So there is Section 8 that is giving the employer the right to terminate. But Section 15 is telling the employer that if you intend to terminate, which you have the right to, go look at what Section 15 also provides in the law. And it sets out the grounds. I think that council has already mentioned this, so I don't even have to repeat it. So you don't just say, because I have the right to terminate, I am going to terminate. No. Let me
chip in this. You see, if you look at section 63 of the Labor Act, titled Unfair Termination of Employment, subsection 4, if I may quote, a termination may be unfair. Listen to this. A termination may be unfair if the employer fails to prove that A, the reason for the termination is fair, or B, the termination was made in accordance with the fair procedure of this act. Unquote. A termination may be unfair if the employer fails to prove that the reason for the termination is fair. Now, if you don't prove or if you don't give a reason, how do you even show that the reason is fair or not?
The fairness.
You get a point. You need to proffer a reason. It puts a duty on you, the employer, to proffer a reason, and not just that. The reason must be a qualified one, and the qualification is that it must be a fair one. So it is not just enough to even just give any reason. That is how, forward-looking the Labor Act, is. But you will notice that the courts have been a bit romantic around the Labor Act. It appears they are a bit edgy in applying the full extent of the Labor Act because you see, they are still comfortable with the common law position. You see, but it is very clear that it will be unfair termination if you terminate the employment without giving reasons. The only situation where you're not required to give reasons is the situation of summary dismissal based on grave misconduct.
Yes.
Hello.
Hello?
Yeah, Dennis. I'm enjoying the discussion with you and then Stephen.
So that is what the answer is.
And the answer
because you see,
let's listen to
yes, and then a quick addition to what Dennis was saying earlier. Now, like he mentioned, it has to be by a fair procedure. Now, let's even say that it is not according to a fair procedure. The same law is telling you that if it's not going to be according to a fair procedure, it should be by provisions of the very act. And that very act is saying that, yes, you can terminate, but then again, you must establish the grounds first before you even think of giving notice. So to say, I have given you notice, or I am paying you salary in lieu of notice, so it is enough and we are ending the relationship, then you are forgetting that there is a certain section 15 that puts an obligation on you as an employer to provide or to establish grounds for which you are saying, my intention is to pay you notice to end the relationship, or give you notice or pay you salary in lieu of the notice for us to end the relationship.
Okay, so let me try and shift the discussion a bit. You know, once we are signing contracts, we are drafting our own laws in terms of its applicability. If the termination clause in an employment contract is clear that the employer reserves his right to terminate your employment by giving you notice. If I terminate without giving you notice, I pay you 1 month in lieu of notice. Would that not be deemed as a contract which has been mutually accepted by both parties, and so therefore the contract should be respected?
It's the Onesimus. You know, parties cannot contract out of statute.
Out of status. I know.
Right? And there is a duty of the courts to ensure compliance with statute. Hello?
Yeah, then
there's a duty on the courts to ensure compliance with statute. So the employer, this statute was brought to deal with a mischief. All right. And the mischief is that we want to, I think that the idea of the legislator is to avoid a situation where the employer can disemploy an employee at a scream and cap price. Now, if we allow for the employer and the employee to chip into a contract, a provision that allows the employer to do exactly what the statute is seeking to prescribe, that will be defeating the purpose of the statute, isn't it? That will be defeating that will be subverting the cause of the statute.
And just one quick addition. There are times I feel, and this is a personal feeling, there are times I feel the law, the courts keep shying away from what the provisions of the labor law provides, because then it seemingly kind of takes away that authority or the strength it has in determining some of these cases and putting it solely at the jurisdiction of the Labor Commission. So it's like the court has given the Labor Commission, the law gives us some authority, but then the court in some way by its actions it takes a little of it as and when it feels that, oh no, on this one, we think that the common law position should ride over the labor law. But you find that in those same courts, there's a reverse where they would say, if there's a law specific on the relationship, i.e. the employment relationship, then that is what should stand and not what the common law position is.
Hello.
Hello?
Yes.
Yes.
So
So
I'm very interested in this case that you were referring to, which was decided in 2019.
yes.
Is it the case that the Supreme Court did not deal with the Labor Act at all? Because that would be very interesting. Because
Yeah,
as I know,
from the look of from the reading of the judgment, this was the particular references to the aspect about termination. And it was kind of a bit clear that hence either party has the right to bring the contract to an end, just as the concern that I raised in my initial thoughts that it's not a contract of servitude. So in as much as I can't force my employee or the individual to work for me, I cannot also be forced to work with the person. So either parties at a point must be given the right to several ways. I mean, if I say, oh yeah, and then if you decide to let them
but
I don't know whether you have read this case of Bunny versus Myers Ghana Limited, civil appeal number J448 2010.
This is 2019.
Yes, this is 2019. But,
no,
but your own,
2019.
yes, but your own, hello, but your own, the Supreme Court appears. I've not read the case, and you have not also mentioned whether
I'm
they refer to.
I'm not really dealt with it, so I can't speak to the facts.
Wait,
it's just
so,
okay.
I don't know whether your lordships dealt or mentioned the issue of the Labor Act, because there is no way they can deal with an issue on termination without referring to the Labor Act.
Referring to the Labor Act.
All right. Unless, of course, the facts of that particular case happened before the coming into force of the Labor Act. But even that one, to my mind, they would have at least mentioned it in orbital.
Yes.
Because the case which I know that they dealt with the issue of the coming into force of the Labor Act is the case of the Bunny versus Myers Ghana Limited civil appeal. That one, they talked about the implication of the Labor Act. And this is what the Supreme Court said. Yeah. The Supreme Court unanimously held that they held that the concept of fair and unfair termination as a cause of action was not a common law principle. It was not a common law principle. And I've already mentioned what the common law principle is, which is based on the mutuality principle you have been talking about. So they said it is not a common law principle. They said it is a legislative intervention brought about with the passage of the Labor Act 2003, Act 651. Nevertheless, this legislative intervention did not make this new concept actionable in the law courts at the suit of a party to an employment contract.
Okay.
Hello?
Yes,
Yes.
I can hear you.
Yes. Rather, the legislation in making the intervention created a specific body to handle such complaints, and that is the National Labor Commission, not the law court. So, taking this particular case, I will not be too surprised that the Supreme Court, in the case you are referring to, will go by the mutuality principle, because in this case, they clearly stated that as for the courts, they will deal with the common law principle.
Okay.
Right? And that the concept of fair and unfair termination is not a cause of action actionable in the court per se.
Okay.
Right?
Okay.
Which means that if you
Dennis, I'm listening.
Hello? Yeah, so
Yes,
which means that
I'm
if you
listening.
come to the court, as for the court, they will use the common law principle. That is what this case seems to be saying. So if you want to use the fair and unfair termination issue, then you go to the National Labor Commission. That is what the Supreme Court seemed to be suggesting from this particular case. Now we are yet to see a scenario where a person will go through a National Labor Commission, and the National Labor Commission will make some findings and recommendations, and then proceed to the court for the court to make enforcement on those recommendations. Then we will know whether the court will sanction the decisions of the National Labor Commission based on the Labor Act, the fair and unfair termination. We don't have a case like that.
Now, even back to the fair and an unfair. I mean, in when you say fairness, in whose opinion is fairness? Is it the Labor Commission's opinion or what?
Say again.
I said if you look at the act, it says that something is unfair if termination is unfair if it wasn't done in a fair way. So the act itself has failed to determine or explain what fairness is. Is it fairness in terms of what the Labor Commission, in the opinion of the Labor Commission, fairness is deemed to be, or what?
You know,
no, you see,
go ahead.
you see, even though, like you mentioned, the act doesn't explain what a fair action is, it still goes ahead to tell you that the termination should be according to a procedure. Now, let's say there's an alleged offense. So I have done something and my employer contemplates letting go. Now, by the rules of natural justice, at least I should be given that opportunity to be heard so that I can either defend my actions or my actions is seen to, in the end, to show that what I did was wrong before the employer can go ahead and do whatever it is that he wants to do. So the law may not say fairness would mean that A, B, C, and D. But then again, it is the onus lies on the employer to ensure that whatever action or whatever reason, whether stated or implied, for which he intends to end a certain employment relationship, some procedure should be seen to have been conducted before the relationship is terminated, so that it is not seen that, so you wake up one morning and you don't like the look on my face because I'm wearing a beard now. And so because of your beard in my head, you say I should go home. You have paid you notice, or I've given you notice, or I've paid you in lieu. So go. At least, even if it is about my beard.
Let me finish this. And that is my challenge. That Dennis, as you also said there, or Stephen, as you said there, if you make applications to so many companies, and then one morning one of them calls you that I'm giving you 500% from what you are taking, you will just look in my face as an employee, and tell me that I'm resigning effective immediately. You can take my 1 month notice. I don't mind. So I mean, my point is that in as much as I can't look in your face to say that because of your BS go, the same way an employee should also not be allowed to just resign if that's the case. If that is not the case, either ways, all of us must be given the right to terminate. One is resigning, I am terminating. So that is to me fairness.
Hello, Onesmus.
Yes.
Yeah, so now on the question, what constitutes fairness?
Well, if you ask me which of the two is.
On the question, what constitutes fairness? If I may just contribute briefly.
Sure.
Yes, the Labor Act actually provides some indicators of what is unfairness. If you look at section 63,
yes,
which deals with unfair termination of employment. Okay, unfair termination of employment. Subsection 1 says that the employment of a worker shall not be unfairly terminated by the worker's employer. Subsection 2, a worker's employment is terminated unfairly if the only reason for the termination is...
I've shared the screen so the viewers can also see it.
Great. So,
yes.
So if you look at the proviso of subsection 2, it goes to enumerate, or it goes to stipulate what will constitute unfair termination. There is unfair termination if the only reason for the termination is that the worker has joined or intends to join or has ceased to be a member of a trade union or intends to take part in the activities of a trade union, or in the case of a woman worker due to the pregnancy of the worker or the absence of the worker from work during maternity leave. So for instance, employer cannot take advantage of a pregnant woman, that because the woman is pregnant and has been absent, she takes advantage of the situation and terminates her pregnancy. That will not be a fair reason for termination. Or that the worker seeks office, as or is acting or has acted in the capacity of a worker's representative. That the worker has filed a complaint or participated in proceedings against the employer involving alleged violation of this act or any other enactment. So it goes on to stipulate some scenarios that cannot be a good reason for termination. And so if any of these scenarios come into play in a termination, right, then it can be deemed to be what? Unfair. Hello?
And that also brings in another angle, that if I terminate and it doesn't fall within these reasons, then it is fair. Because the act has clearly listed what it deems as unfair.
No, but if you look at 62, but if you look at 62,
not necessarily.
If you look at 62, it tells you what a fair. If you look at 62, it tells you what a fair, what a fair termination should look like.
Termination
now, yes, 62A is saying that the worker is incompetent or lacks the qualification in relation to the work for which the worker is employed.
Yes.
B, proven misconduct. C, redundancy under section 65. And then D, due to legal restrictions imposed on the worker, prohibiting the worker from performing the work for which he or she is employed. So the law is saying that these 4 instances would mean that if any of these instances should come up, then the employer has the right to terminate, and the law will consider that termination as being a fair one.
Okay.
Yes.
Okay. I mean, we've passed the 1 hour break now.
You don't say.
Yeah, we are 1 hour. We've done 1 hour already. So
okay.
Stephen. Now back to your jurisdiction or your arena. If I am an employee and I get my contract terminated, what are the practical steps that I need to follow if I need to come to the Labour Commission? Okay.
So first of all, you would have to come to the offices of the commission. If you are in Accra, there's the head office, which is adjacent to the Ridge Hospital. And if you are in Tema and its environs, we have a new regional office here now. We are in Community 10, the Mayflower House. So when you come, there's a complaint form that you are given to fill out. And then we demand certain details and some other additional documents, i.e. contract of employment, the termination letter, pay slips. If you have any document that will show that, yes, truly, you were in the employ of the said employer. And then once we receive the complaint, there are steps we follow. We serve your former employer, we constitute a meeting, and then we begin with the commission's first step towards amicable resolution of the employment dispute, which is facilitation. Now, if that is not successful, there is mediation, there is voluntary arbitration, there is compulsory arbitration. There's also summary settlement. So all of these processes are available to parties in the event one feels that I have suffered an unfair termination of my appointment. Once you walk into the office of the commission, the procedures would be explained to you, and once you take them, you submit the complaint, the commission will take the matter up.
Okay, so there's facilitation. It can be clear that maybe sometimes at the facilitation, parties may come to a resolution and then the matter will go.
For most of the time, if you look at if you look at the commission statistics, majority of its cases are resolved at the facilitation level.
Okay.
Yes.
Okay.
Because ideally at that level, the parties on their own decide what they think is proper to resolve their dispute. So once they are able to come to that agreement, it's easier because they own the decisions by themselves. If we are not able to if that is not able to occur, that is when those other different dispute resolution mechanisms are kicked in, and then the issue is resolved.
Because of our time, in terms of resolving contractual matters for termination, I mean, that's the majority cases that comes to your office.
True.
What are some of the recommendations or what are some of the decisions that the commission makes? Does it include letting the employer employ back his employee or only compensation?
Well, the act provides for 3 remedies in the event that you have suffered an unfair termination of your appointment. Now, the first is that the commission may order the employer to reinstate you to your position. The commission can also order a re-engagement or a re-employment. And then in the circumstance where we think that or the situation looks as if too much water has gone under the bridge and that getting the relationship back again is going to be a difficulty, then the commission will order for the payment of compensation for the unfair termination if it is determined that it is unfair.
I'm looking at instances where clearly you have taken me to court as I am your employer. You take me to court or to your commission, and then the commission is telling me to pick you back. I mean, in terms of relationship and stuff, commercially, it won't be prudent for most companies to go by that side. Lord Daniel, I mean, time is fast spent. Let's also engage our audience. If anybody has any question, the person can unmute themselves and then ask the question. We have like 10 minutes to wrap up before we move on. So now the floor is open to any person. If you have any question whatsoever, you can ask, and then our able expertise here will assist us with resolving them. So my first question is that somebody wrote, this is to Dennis, that can oral contracts also bind companies? That was the first question that came out. And the second question was that, can we amend an existing contract? So the first one was an oral contract and the second one was amending a current contract.
Yes, to answer the question simply, yes, you can have oral contracts. Yes, you can have. If you look at the Labor Act allows for, I mean, both oral and then written contract of employment.
Okay. But how do we enforce oral contracts, especially when I want to terminate based on grounds of non-performance? Because the contract is not written, how do we determine that I told you to do A, B, C, D, for which you failed, and that you're not performing? And is it advisable to go by local oral contracts?
Great. So yeah, so if we are talking about what is advisable, then of course it is never advisable to have, I mean, oral contracts of employment. But in the event where your contract is premised on oral or verbal agreement, right? In that situation, of course, you know that there are other ways of proving the existence of a fact other than, I mean, written document. Written document or documentary evidence is always to be preferred. But in the absence of a documentary evidence, there are other ways of establishing facts and not necessarily resorting to what do you call it, to the document. So to answer your question simply, it is always to be preferred that a contract of employment is reduced into writing for ease of reference when there is an issue as far as the contract terms are concerned. And I believe that most institutions, well-established institutions normally would give a person a written contract for their mutual benefits.
Hello, I'm Charles.
Charles, go ahead.
Yes, and then
Okay.
you also
Hello.
mentioned whether, a person can subsequent to a written contract alter the terms of the earlier contract, if I got you right.
Yes, Dennis.
Hello, Nismon.
Yes.
Was there a question to that effect?
Yes, in amending existing contracts.
Yeah, so that is what we call collateral contract. So yes, you can have a subsequent alteration of a main contract after the parties have reduced the contract into writing. You can have a situation where some terms of the contract is altered. It can even be done orally or even by conduct subsequent to that. But it is always preferred that if you intend to alter the terms of the contract, what I have seen is that in practice, the main contract will provide for that in an event that you want to alter the terms of the contract, the way it ought to be done. They sometimes will say it ought to be done by writing. So if you want to alter the terms of this contract, then it has to be done by writing. Then of course, in that situation, if there's a subsequent change orally, and you come to court and you want to establish it, it will be almost impossible because the main contract specifically requested or required that if you want to alter any provision in it, it ought to be by what? By writing. But yes, the law allows for what we call collateral contract, whereby a main contract is altered subsequently by the parties. It has to be done by the mutual agreement by the parties so that an employer cannot unilaterally alter or seek to alter the terms of the employment contract. And the employee, of course, cannot also unilaterally seek to change the terms of the employment contract. It has to come by mutual agreement. And if it is done, it has to sit within the main contract. If the main contract requires that it ought to be by writing, then it ought to be by writing. Otherwise, the parties can even alter the express terms of the main contract, even orally. And the law allows for that to happen.
Charles, please go ahead.
Hello, Charles.
If Charles is not ready, any other person can ask the question.
But
Or
I think that you would have to unmute all of them.
Okay. Let me. Dalvin writes, in case of contract sign has clauses which is not in line with the act, when there's termination, what supersedes the other? Are you binded by the contract or the act?
In case of termination, the act will supersede the contract that the parties have signed. Yes.
Sure. Any other question? All right, I'm sure each and everyone here really understood what we said. So let me start from Stephen. Any advice to business people, because we are going live on Facebook and it's always broadcasted on our YouTube channel as well. What advice do you have for people in terms of how they relate with their employees?
Well, I think that from the very beginning, how they intend the relationship to last should be made clear. And I think that some of these things can be made clearer when the contract of employment is written and written properly, because ideally it is more or less the first regulatory tool when it comes to managing the employment relationship. And so the advice to everybody watching us, whether you are an employer or even an employee, is that when you are giving a contract of employment, take the pain to get to understand everything that is required of you in that employment or in the offer that has been given to you before you sign on to, so that it is not when at a later date when there's an issue, that is when you come crying that, oh, but you should have said this, but you should have said that. And the advice goes both ways, even for employers, because you are investing in somebody. And so you should make sure that how the investment is protected is made clear. So you don't seem to always be bringing in people 2, 4, 5, 2 years later, 3 years later, they are going out and you have to bring in new people again. So let's make it as clear as we can when it comes to the contract of employment.
Dennis, do you also have any last words for both employees and employers?
Okay, my advice will be to employees. I think during my research and my studies, I realized that there is that seemingly confusion as far as the Labor Act is concerned and case law is concerned on whether the employer can terminate the contract of employment at his own whim and caprice without giving any reason. On one hand, which exists at common law and which is being practiced by the court, and then also the Labor Act. And it appears that the courts have been, as it were, dodging the situation of the clear words of the Labor Act, which says that you cannot terminate the contract of employment without giving reasons. It is clear. The concept of terminating contract of employment without giving reasons seems not to be envisaged by the Labor Act, right? So I would advise any employee whose basis of challenging the termination of contract that he was not given any reasons, I would encourage them to go to the National Labor Commission, because I would be very happy to see a situation where an employee will go through the right procedure so that if the matter eventually comes to the court, it will be properly laid before the court for us to know once and for all common law, which says that an employer can terminate contract of employment without giving any reason, or that the Labor Act, as having stated that you must give fair reasons, should apply. I think that because mostly the steps which are taken by employees are ill-advised, they are not able to put themselves well before the court. So the court doesn't touch on the issue proper. So my advice is that if you have any issue, go to the National Labor Commission. That is why my big man is there. I'm sure his contact will be made available so that if anybody needs any form of assistance, they can contact him so that the case can be properly laid before the court for we, the lawyers, to see what the courts will do once and for all. Thank you.
All right, so Stephen, please give your number out so that if anybody has any labor-related issue, they will call you for guidance and directions.
Okay, so the number is 0506 899
0506
899
99948.
Yes.
All right, so I've shared it on the chat section 05068994948.
Yes.
05068994948. Okay. Okay, so if I call this number, is it your personal number or is it the commission's number?
It is the office number, and it's a mobile number. So when you call,
okay,
you can trust that you get to speak to me. Yeah.
Sure. All right. Lawyer Dennis, please give your number so that if anybody needs a counsel to represent them on labor-related issues and they are in Kumasi or even in Accra, if they have money, they can fly you to come to the National
Oh, if they are in Kumasi, they should go to Ahunjo. We have an office there.
Oh, okay.
Yes.
No, I mean,
This man is trying to prevent
even if
anybody
the
from
person
coming
is,
to
even if the person is in Accra and they requires the presence of Dennis, they can fly him in there, get you
A nice hotel, you know.
Port View or
Kempinski,
go and relax, and then Kempinski is even closer to their office so that you can relax and go and advocate for them. All right, then, so we need your number.
Yeah, on this one, I just hope it will not be contrary to our code of ethics, and it will not.
No,
be
this is purely for educational purposes, and then more or less like a pro bono stuff. So
very well. And I mean, I want to just say that if we want to even go to the National Labour Commission, you can still engage a council to represent you.
Exactly.
It is very important. Very, very important.
Yeah, so it's not like you have to, it's either or, you have to choose between the National Labour Commission or a lawyer.
Or a lawyer, yes.
On that issue, Dennis, before you give your number, let me confirm from Steven. I know in Accra there are lots of consultants that come before you, and taking into consideration that the Labour Commission is more like they have the jurisdiction of a high court. Do you encourage consultants to be flagging your offices and representing people?
Well, these consultants are persons who are vexed in the operations of the labor law. So yes, the commission allows that they come in so that people who can't come and have freely express their issues, they seek their service, and then they in turn come and help them out. And you find that in as much as we get consultants trooping in, we get a lot of the lawyers coming in as well. I think I have met Dennis 1 or 2 times at our end. Mm-hmm. So yes, we are open to labor consultants. Let me be specific. So that it's not just...
How legal are labor consultants appearing before a commission which has the capacity of the High Court? Oh, I will engage you after the discussion. So you, Dennis,
sure.
Yeah, Dennis, give us your number and then we can
My number is 0244
0244
44
44
49 94. That's right.
0244 44
yes
44994.
Yeah.
No. So 02 then 54994. 02
okay,
02
okay, 025494
994. Yeah, that's right. That is correct. The number displayed on your screen is correct. Yes.
Sure. All right.
So I will partner with your big man over there. If there are some lawyers who, some clients who need lawyers, they can also.
Exactly. I'll give you a number. I'll give you a number.
Yes. Dennis, we'll talk.
Yes. I'll give you a number to Dennis and then
we'll talk.
All right.
Yeah. All right. So on behalf of Lawyers Diary, we want to thank Dennis and then Stephen for your time and insight. I personally learned a lot, and I've also enjoyed the discussion that ensued between us. The essence is to educate the masses, to let the people know the position of the law, and also be informed on the right steps to take should they require any legally related resolution of their matters. So the Lawyers Diary comes your way each and every Friday at 6 p.m., 6 to 7. And because of how the discussion go, I didn't even realize that we've exceeded an hour and 20 minutes, and we had a lot to discover as well. So we'll find another time and then delve deeper into the issues by comparing the cases and see how the court and then the commission, in terms of record and statistics, have resolved labor-related issues. You can visit our social media pages on the Lawyers Diary at Instagram, Lawyers Diary Global, and then subscribe to our YouTube page. This will also be posted on our YouTube page, Lawyers Diary, so you can follow each and everything that we do. Thank you all for coming. Thank you all for your time, and we really appreciate this. Thank you.
Thank you.
All right, so see you next week at 6. Bye.
Okay, bye.
Bye.